Okay, we're good to go, Pipi.
Thank you very much. What an honor and a privilege it is for us as the AORC-AOMA, the IOR family today, to be graced by your presence, Advocate John Walters. We are really, really pleased to see you still being part of our family. You are an integral part, really, of the history of ombudsmanship. And thank you very much for joining us, and welcome, Dr. Nasir, Jamal, Pasha. You are welcome, sir, and thank you very, very much for gracing us. And the SG of AOMA, Honorable Caroline Sokoni, colleagues, staff members of Ombudsman across the world. And it is quite a pleasure that as the AORC family, we know that not only are we sharing information, not only are we receiving knowledge amongst ourselves in Africa, but we know that AORC has also extended its footprint to other parts of the world. Really looking at today's topic on ensuring effective execution of the Ombudsman's recommendation. And in the case of the public protectors, it is the implementation of the remedial action. Now, distinguished guests, I really, really bring you warm greetings from Public Protector South Africa, from AORC. Now, today's theme really strikes at the heart of our collective challenge as ombudsman institutions across the world. While we have become increasingly effective at investigating complaints and identifying systemic problems, the effectiveness of the ombudsman is fulfilling its mandate is multifaceted, serving as a bridge between the state and its citizens. The true measure of our success really lies in our findings, but in the transformation that these findings bring to the lives of the citizens whom we serve. Now, the unique journey of South Africa, and which I know that even across the globe is what really bothers us. It's what makes us to be either effective or ineffective. Now, unlike many classical ombudsman institutions that can only make recommendations, for us in South Africa, the constitutional empowerment that we've been given is to take appropriate remedial action. Now, this distinction enshrined in our constitution has fundamentally transformed the nature of our work and the expectations placed upon it. Just during June month, I had the pleasure to address the Parliament of Malta on the effectiveness of our remedial action, and which then shows that there's an increased interest across the globe in the kind of characteristic of the powers that the public protector has in South Africa. Now, the journey to establishing the binding nature of our remedial action was not without challenges. The Constitution is very clear thereon. However, it had to take the Constitutional Court in the matter of the economic freedom fighters to actually confirm the binding nature, to confirm what is in our Constitution. The former Chief Justice had emphasized that compliance with remedial action recommended by the public protector should not be optional, and that remedial action taken against those under investigation cannot be ignored without any legal consequences. However, what the courts have also emphasized in South Africa is that a recommendation doesn't mean that you can then ignore because it is a recommendation. There must be just a reason why you are not implementing a recommendation. Whereas with a remedial action, it has to be implemented unless it is set aside by a court of law. Now, the binding powers I must share, they basically are a double-edged sword and have been for us. While the binding nature of our remedial action has strengthened our constitutional mandate, it has also presented new challenges. An immediate increase in litigation reflects a fundamental shift in how state organs initially engage with our findings, from a culture of voluntary compliance to one of legal contestation. However, what we've observed, particularly since I've been at the helm from 2022, is that the implementation of our remedial action has actually increased. We were at 2% initially, and currently we are at 50%, which has actually even encouraged us to make this a deliverable within our objectives, because that is where the impact lies, where the prejudice has been redressed, has been addressed. Now, this actually suggests that while the transition period was challenging, institutions are increasingly recognizing the legitimacy and the binding nature of our work. Now, in the last 3 financial years, we've actually only had 7 reports which have not been implemented, which basically actually shows that we are on the right path. And the judicial reviews of our matters has actually even dropped drastically. Now, the South African experience underscores the crucial role of Parliament in ensuring compliance with Ombudsman recommendation, and established in our Constitution, particularly in the Nkandla judgment, where Parliament has a constitutional duty to assist and protect the public protector to ensure its independence, impartiality, dignity, and effectiveness. The National Assembly or any other parliament must put in place mechanisms and processes to hold the executive accountable for the implementation of the work and the impact of the work that Ombudsman across the board do. Now, the parliamentary oversight function is particularly important and as important in our context, in the African context, where the checks and balances expected to exist between the various organs of state are actually weak, and the rule of law is not often regularly observed. The South African model demonstrates how constitutional provisions requiring parliamentary support and protection can enhance Ombudsman effectiveness. This includes regular reporting obligations to maintain oversight, parliamentary questions and committee hearings on implementation, legislative support for Ombudsman recommendation. Now, how do we strengthen this implementation and practical strategies? Now, there has to be built in robust internal follow-up systems, drawing from the best international practices and our own experiences. Effective implementation requires a systemic internal follow-up mechanism. The International Ombudsman Institute's research identifies several key elements, which I really would like to share with you. Dedicated monitoring teams responsible for tracking implementation progress, regular reporting requirements from public bodies on remedial action compliance, escalation procedures for non-compliance, including senior level engagement, and engagement of political role players, public reporting on implementation status to maintain accountability, but also for the public to know how the executive is faring on accountability, because true accountability is accepting consequence. There is no accountability without consequence management. Now, the collaborative approaches and stakeholder engagement. The strengthening of Ombudsman institution lies not in coercion, but in collaboration and persuasion. As Stephen Owen observed, and I shall quote this, through the application of reason, the results are infinitely more powerful than through the application of coercion. This requires the following approach: building strong working relationships with government institutions, maintaining dialogue throughout the implementation process, providing support and guidance to institutions struggling with compliance, and recognizing and celebrating successful implementation to encourage positive behaviors, I unquote. Countries like South Africa, Ghana, Uganda have demonstrated that hybrid models with enhanced powers can be effective, and so has Zambia. The African Ombudsman Research Center plays a crucial role in coordinating activities and supporting ombudsman officers with research, information, capacity building, and advocacy. This collaborative approach, facilitated by AOMA, ensures that best practices are shared and institutions learn from each other's experiences. Now, a way forward and the proposed vision for effective implementation. As we look into the future, we must recognize that the true power of ombudsmanship lies not in their investigative capabilities alone, but in their ability to transform findings into lasting improvements for their citizenry. This requires a fundamental shift from seeing ourselves merely as grievance handlers to becoming catalysts for the transformation. Modern ombudsman officers must leverage technology to enhance their follow-up and monitoring capabilities. This includes developing robust case management systems. We have developed ours as the public protector, and I must say, it is assisting us a lot. Automated reporting mechanisms and data analytic tools to track implementation patterns and identify systemic issues. The strength of individual ombudsman institutions is amplified when they work collectively. AOMA's role, and particularly that of IOI at a global level, is facilitating peer learning, sharing best practices, and advocating for stronger legal frameworks through AORC is crucial for the continued development of ombudsman institutions in Africa, and now the influence that we've had to the world. Ultimately, effective implementation depends on fostering a culture where compliance with ombudsman recommendation is seen as a mark of good governance rather than as an administrative burden. This requires sustained engagement with government institutions, civil society, the state at large, and the public to build understanding and support for the work of the ombudsman. In conclusion, allow me, colleagues, as we participate in today's webinar, let us remember that our work serves as a higher purpose, ensuring that no citizen suffers prejudice or injustice as a result of wrongful actions of organs of state. The journey from investigation to implementation is complex, but it is where our true impact lies. The South African experience demonstrates that while binding powers can enhance effectiveness, they must be accompanied by strong institutional relationships, robust follow-up mechanisms, and sustained parliamentary oversight. Most importantly, we must remember that our powers lies not in the coercion, but in our ability to reason, persuade, and ultimately transform the relationship between the citizens and the state. I really look forward from learning from my colleagues on this platform today about their experience and innovations in strengthening implementation. Together, we can ensure that ombudsman findings are not just heard, but are acted upon, creating lasting change for the people we serve. Let us make this webinar a catalyst for transformation, moving from voices of reason to agents of change. And thank you very much. I really, really look forward to hearing from the colleagues on the platform whom I've already recognized, but also let me also recognize our facilitator, who's highly esteemed and knowledgeable, Honorable Tejan Ahmed Israel Jar, who is a barrister and solicitor of the High Court of Sierra Leone with over 15 years of legal experience, who has began his career at Shares Moses and Company and Marcus Jones and Company law firms, later serving as a magistrate in the judiciary of Sierra Leone. He has extensive experience in both private and corporate sectors, holding key positions in government agencies such as legal officer at the Right to Access Information Commission and acting director of legal affairs at the Social Security Institution. In private practice, he has worked with NGOs like Advocate and Defense for Children International, providing legal aid to indigent women, girls, and juveniles. Tejan Jar lectures at the University of Makeni, IPEM, and Jala University, and serves as a council member on the General Legal Council. He holds an LLB degree from Fora Bay College, an MBA from IPEM, and an LLM from the University of Salford in the United Kingdom. So we are truly, truly privileged to have such stature sharing with us. And thank you very much for making the time to join us. You are welcome. Over to you, facilitator.
Thank you very much. Are you getting me?
Yes, very clearly. Thank you.
All right. Thank you very much. Thank you for that introductory speech. Ladies and gentlemen, good morning and welcome to this special webinar organized by the AORC and in partnership or collaboration with the IOI. Ladies and gentlemen, my name is Tijan Ahmed Israel Jah. I am the National Ombudsman of the Republic of Sierra Leone, and it is my pleasure to facilitate today's webinar, which is themed Strengthening Implementation, Ensuring Effective Execution of the Ombudsman Recommendations. Firstly, I want to extend my sincere thanks to the organizers, particularly the AORC, led by Advocate Kuleka and her dedicated team from the organization, and also the, of course, AOMA-AORC, which has consistently worked to deepen awareness and knowledge among ombudsman institutions across our continent. They have actually put together what promises to be an insightful, educational, and highly interactive session. Ladies and gentlemen, we all understand that our core mandate is to grant access to justice for our people who have suffered or are suffering maladministration and other forms of injustices. However, the true measure of our impact isn't just in issuing findings, but in ensuring that those recommendations lead to meaningful and tangible change or changes. Consider this: an ombudsman institution's strength isn't just about identifying the problems or the complaints that were brought to it. It's about seeing that our recommendations are implemented to the letter, which in fact, in my view, would grant justice to the bereaved or to the aggrieved party. This webinar, I believe, ladies and gentlemen, will precisely explore that. We will delve into the internal mechanisms or systems, frameworks, and strategic approaches that ombudsman offices can use to effectively monitor, follow up on, and encourage compliance. We will confront common challenges like institutional resistance and limited enforcement powers. And crucially, we will share practical strategies to overcome them. Today, ladies and gentlemen, through this webinar, we aim to explore how we can ensure that our recommendations truly result in systemic change or changes, and also that they strengthen the rule of law and uphold citizens' rights. Let's learn from each other's experiences and case studies to enhance our collective impact. Well, joining me today as our speakers is an array of distinguished experts in their various fields who have been helping us discuss or who will be speaking on various issues to make this webinar very interesting. Ladies and gentlemen, however, I'm having some. Hello, are you getting me? Hello? Hello?
We can hear you.
Okay,
Can hear
I'm having some glitches, that's why.
Not a problem, Honorable.
Okay. Ladies and gentlemen, like I was saying, we have some panel of experts who will be helping us delve into these issues, and they will be giving their viewpoints on the issues that we are discussing. First of all, ladies and gentlemen, I want to invite to the discussion panel the Honorable, hello? Hello?
We can hear you, sir.
All
We can
right,
hear.
okay. I want to invite to the forum one of our speakers, who is Honorable Caroline Chumuzulu Sokoni. I hope I pronounced the name properly. She is currently the Public Protector of Zambia and the Secretary General of AOMA. She has served in the office of the country's National Ombudsman for 16 years. Honorable Sokoni began her professional career in 1989 as a state advocate under the then Ministry of Legal Affairs, which is now the Ministry of Justice. She has a Master's of Law in Criminology from Queen Mary University and Westfield College, University of London in the United Kingdom, and served under the Ministry of Justice for 15 years. Honorable Sokoni was appointed as Acting Director of Public Prosecutions for the Republic of Zambia in February 2004, and was also appointed as the tax team leader for the legal component of the Water Resources Management Project, a policy formulation body tasked to spearhead the reform of the water resources management process in Zambia. Honorable Sokoni presided over the Town and Country Planning Tribunal as the vice chairperson between 2003 and 2005. In November 2004, she was appointed as the Investigator General for Zambia's National Ombudsman Office. At the time of her appointment, the office was known as the Commission for Investigations. Ladies and gentlemen, I present to you our first speaker, Honorable Caroline Chuma Zulu Sokoni. Welcome, Madam.
Thank you so much. Good morning or good day, esteemed colleagues. I recognize as well the presence of Advocate John Walters, who was our first African president of the International Ombudsman Institute. You're welcome, sir.
Thank you.
Thank you so much. The topic I have been asked to present on is a very interesting topic. It is the internal mechanisms ombudsman officers can adopt to improve the follow-up and implementation of their recommendations. This includes institutional tracking systems, legal powers, and internal procedures for ensuring compliance. The ordinary description of an ombudsman role is simply to promote justice, transparency, and accountability, and to that end, enhance the performance of the public service delivery system in a given jurisdiction. That understanding has permeated to the government who give the institution the required statutory and constitutional mandates to investigate complaints against the self-same government regarding the proper delivery of public services to the people. By design, the Ombudsman Office is meant to carry out its investigations independently of the executive arm of government because it investigates the government in its implementation of a delivery of social services to the people. Depending on which side of the economic divide you are speaking from, the type of internal mechanisms used by the Ombudsman may be preferably binding, or they may be by way of recommendations. In the Western jurisdictions, where the concept of the Ombudsman arose from, the use of enforcement of the reports of the Ombudsman by way of issuing reports which only have the effect of recommendations is primarily used. But in a growing development among African countries, the use of issuing reports by way of binding powers has become more in use. In general, Ombudsman officers face similar challenges in the enforcement of their recommendations, because the two terms, recommendation and enforcement, seem to be at odds with each other. A recommendation is just that, merely an opinion containing findings after an inquiry or investigation has been carried out, and suggestions on how best the matter may be resolved. Where an inquiry has been carried out regarding a specific subject matter, it means there was a problem which had to be resolved. The Ombudsman thus may also be seen as an independent problem solver, specifically created to resolve problems in governance within a jurisdiction. However, a difference must be drawn between other problem-solving bodies within the government and the role of the Ombudsman. Primarily, other problem-solving bodies within the government may be regulatory authorities, the ministries, the departments that have been set up, and these government institutions resolve problems by way of applying the law strictly, or by way of applying the regulations strictly, or either by way of procedural guidelines. There is very little discretion given to these government institutions. And normally, when an Ombudsman comes in to resolve a matter of maladministration, it may be either these rules or regulations have been applied too strictly, or the law has been applied too strictly without looking at the peculiar circumstances of a particular case. And it is therein where the difference must be drawn between the work of an ombudsman in resolving problems and government departments in resolving problems. The ombudsman, because he works independently, because he or she works independently, must create systems, must create ways in which the decisions or the reports of the ombudsman must be complied with by these government departments. So in order for any well-organized systems which provide services to the people to run properly, it must be able to solve problems for the people. The government provides basic services such as policing, provision of health facilities, security, etc., and all other services which make it possible for people to enjoy a decent life and enjoy access to basic services. The government offers services to the people in order to ensure uniformity of access to solutions. The people have a problem, the government resolves that problem, but only on a country level, not for the benefit of the single individual. The ombudsman will come in and resolve a problem peculiar to that particular individual, peculiar to a particular sector, and ensure that the procedural guidelines, the regulations, and the law are applied accordingly. in order to give effect to the reports of an ombudsman in a parliamentary ombudsman system, the ombudsman will submit his reports to Parliament, and these reports do not have binding effects. However, in jurisdictions such as Zambia and South Africa, the reports of the ombudsman have binding effects. Having stated that the ombudsman reports in the parliamentary system are not equivalent to a court decision which is binding and must be obeyed and implemented by all parties of the law, the ombudsman concept is not without means of enforcing the recommendations contained in its reports. Although the reports of the ombudsman are not subject to judicial scrutiny, the ombudsman also cannot have recourse to the courts of law to enforce the implementation of its decision on the same grounds that the office its reports cannot be challenged in the courts of law. This is because the reports of the ombudsman are not binding, and you cannot challenge what is not binding and therefore not enforceable. The means of enforcing the recommendations contained in the report of the ombudsman has been and still is the legislature in a parliamentary ombudsman system. In almost all jurisdictions where the classical ombudsman concept has been enshrined into law, the appointment, removal from office, and general oversight of the office is a function of the legislative branch of government. It is submitted that this is also an internal mechanism of ensuring compliance by the executive. The fact that the ombudsman is appointed independently by the legislature and the conditions of service are regulated by the legislature. So it allows the ombudsman to work independently and to issue recommendations independently, which must be implemented by the executive branch of government. However, in an executive ombudsman system, without the protection provided by the doctrine of separation of powers, as applies to a parliamentary ombudsman, implementation of an ombudsman decision is only possible with the tacit consent of and cooperation of the government department, which was the subject of the investigation. Therefore, for the ombudsman to compare compliance is an almost impossible task to achieve for the ombudsman on his own. And therefore, you will find that, as was the experience of Zambia, when Zambia first was an executive ombudsman system, and under the executive ombudsman system, the reports of the ombudsman were enforced by the president. So where the government departments were not complying, then the investigator general would submit the reports to the president for implementation. I believe that is what must apply in countries, for example, where there is a monarchy. I would give an example of Morocco. In other jurisdictions, where the ombudsman operates an executive system, the office reports directly to the head of states. In other jurisdictions, such as Zambia and South Africa, the ombudsman's enabling legislation accords the office the power to issue binding decisions, in contrast to a classical ombudsman system, which nestles and entrenches its authority on Parliament's constitutional role of providing scrutiny over the excess use of executive powers. There are many who argue that even the parliamentary enforcement mechanism may not be quite enough nor hard-hitting enough on the executive. This is where, for instance, the whip system is used by the government to ensure that the report of the Ombudsman is not implemented by Parliament. Lack of enforcement mechanisms does much to hamper the effectiveness of the office of the Ombudsman. Even with the available statutory mechanisms, it is still difficult for the office to ensure compliance with these recommendations. Even where policy reforms and legislative frameworks have been introduced, there is still a high level of non-compliance with the recommendations of the Ombudsman. I note that the Public Protector South Africa stated that there is now a high level of compliance in South Africa. She has given the percentage of 50%, at least 50% compliance. I submit that even then, with the 50% compliance, where the Ombudsman is issuing binding decisions, it would be better for the compliance levels to be much, much higher. The binding power is an internal enforcement mechanism because it is the Ombudsman who issues the reports. In Zambia, we have binding powers, but our enforcement levels stand at 30%. So if you have parliamentary ombudsmen who are issuing by way of recommendations and their enforcement levels are still at below 50%, and you have countries like Zambia and South Africa where the enforcement levels are standing still at about 50 to 60%, then we now have to look at other internal enforcement mechanisms which can help to ensure that the Ombudsman garners enough compliance from the executive. Currently, the Ombudsman in Zambia is empowered by law to investigate, monitor, and evaluate administrative activities and advises the government on good administrative practices. This is entrenched in the law. The Office of the Ombudsman in Zambia.
Apologies, Honorable Sokoni. I think you have something about between 5 and 7 minutes.
Oh, thank you very much.
Okay.
You just.
Apologies.
Thank you. Other internal mechanisms, compliance mechanisms, which are used by the Office of the Public Protector in Zambia include those which are contained in the legislation, that is enforcing the attendance of witnesses and examining them on oath, examining witnesses even outside Zambia, compelling the production of documents, and citing a person or authority for contempt or failure to carry out a decision. The Office of the Public Protector Zambia also has the power to actually recommend for the dismissal or removal of office of a public service employee who is hindering the implementation of the enforcement of a report of the Public Protector. The Office of the Public Protector has also used the mechanism of engaging civil society organizations in order to ensure compliance with the recommendations of its reports. It has also set up different desks within the institution, such as children's desks, disabilities desk, women and elderly persons desk, the youth desk, the environmental and natural resource desk. These are desks which have been put in place once a report has been issued. These desk officers work with the particular sector to ensure that they understand the report and to ensure that the report of the public protector is implemented. The recommendations of the public protector are implemented. The Office of the Public Protector has also signed memorandum of understanding with various civil society organizations to ensure that when investigations are carried out in a particular sector, we ensure that when the report is issued, it is circulated to various sector partners, and roundtable discussions are held to ensure that the report is implemented. Trying to rush through the paper.
Yeah, you just have to take time.
Yes, in developing internal enforcement mechanisms, an ombudsman office must guard against elements of maladministration being replicated even in its own institution. So we have also set a standard within the institution to ensure that laid down administrative procedures do not infringe on the rights of the people in their implementation. So within our own institution, we have created a mirror image for other state-run organizations to ensure that we are least investigated ourselves, because we are also open to investigation by the Anti-Corruption Commission and other wings. Practical and procedural guide. We also try to ensure that cases do not choke up the system by making it more difficult for people to access our services. So we have a system of ensuring that cases are reviewed and monitored so that we do not get choked up with cases within the system. And also we carry out monitoring and evaluation exercises to ensure that after our reports are issued, what is the impact of our reports on the particular sector, so that we do not get similar complaints coming back to our institution. So with these few words said, I would state that the internal enforcement mechanisms have worked more effectively in ensuring that the reports of the public protector are implemented in Zambia. Thank you.
Thank you very much, Honorable Sokoni. That was a very brilliant presentation. I mean, we cannot have a better presentation that's coming from a well-seasoned ombudsperson. Thank you very much for that sound and exceptional presentation. You know, she took her time to go through the topic she's supposed to speak on, and there are a few take-homes which I think I should re-emphasize. I mean, first of all, she mentioned that the law should be applied not too strictly. You know, there is what we call the human side of the application of the law. Even the implementation of the law in a harsher manner could and sometimes induce injustice or maladministration. And she said that uniformity of access to solution must always take place, and that the laws should always be implemented in order to ensure that at least the ends of justice or the objective of justice are achieved. He spoke about the two types of ombudsmen, ombuds institution, that is the parliamentary ombuds institution as well as the executive ombudsman. In the parliamentary ombuds institution, she spoke about the appointment, the removal from office to parliament or through the legislative. And one of the advantages of this sort of ombudsman institution is that it allows the ombudsman to work independently without having recourse to the executive arm of government. And of course, as a result, the ombudsman, ombuds institution in such a setting must present its reports to Parliament. In the executive arm or executive ombudsman situation, she mentioned that compliance is difficult to achieve, or the compliance for the ombudsman's recommendation are sometimes difficult to achieve, because in this sort of setting you need both the political will and political support, which, to be very truthful, has been plaguing most ombudsman institutions in Africa, including the Office of the Ombudsman in Sierra Leone. So you need political will or political support, without which the ombudsman's recommendation cannot be enforced effectively or cannot be implemented, except where you have the intervention or the thorough implementation through the presidency or office of the president. You know, so she also mentioned about enforcement levels. Whilst even where we have countries in which you have the ombudsman's recommendation are enforceable or binding, yet you still have very low compliance rates. So for example, she said in South Africa, there is 50% compliance rate, whilst in Zambia, in our own country, there is 30%. So imagine where in countries where it is legislated that the ombudsman's recommendation are binding, there is very low compliance. What about those countries like mine, where we do not have such legislation, which makes the ombudsman's recommendation binding? So she also mentioned or spoke on the issue of the internal enforcement mechanisms which are legislated for. She mentioned that their legislation makes provision for the compelling of the attendance of witnesses, compelling the production of documents. You also have, they have the powers to recommend the dismissal or removal from office of a public servant who has hindered or failed to implement the recommendations of the ombudsman. She said also that they do and have been engaging with civil society organizations. They signed MOU with civil society organizations, which will ensure that when the reports are released, the reports are shared and ensure that those recommendations are implemented. And another thing which is very important and which I think I have learned from is the fact that by themselves, the institution, the ombudsman's institution in the country would also ensure that their laid down rules and procedures do not incur injustices on complainants who are coming to file a report with the Office of the Ombudsman, or even the respondents or people against whom complaints have been filed. In such a way, it ensures that they are kept under watch, and they also are liable to be investigated by the Anti-Corruption Commission, which will also have similar procedure. So, ladies and gentlemen, I think that's just a brief synopsis of what I understood from the Honorable's presentation, which was exceptionally brilliant. So I will refer you now to our next speaker, who should be Advocate John Walters. Advocate John Walters is the former ombudsman of Namibia between the period 2004 to 2021. He obtained the LLB degree or BA degree in 1977 and LLB honors degree in 1980 from the University of Western Cape in South Africa, and was admitted as an advocate of the Supreme Court of South Africa. Mr. Walters has been a career prosecutor since 1981 and a magistrate since 1985. He spent some time in private practice until he was appointed as acting prosecutor general in December 2002 until 31st December 2003. From April 1998 until March 2006, Mr. Walters was the chairperson of the Transportation Commission of Namibia, He was a member of the board of for legal education from 1996 to March 2008, and an ex-official member of the Law Reform and Development Commission of Namibia since July 2004 until date. Mr. Walters was also a board member of the African Ombudsman Research Center. Mr. Walters was appointed Ombudsman of Namibia in July 2004. He succeeded Advocate BNC Gawanas as the third Ombudsman of Namibia. Mr. Walters joined the International Ombudsman Institute as African Regional Vice President in 2009. He was elected first Vice President and President of the IOI in October 2014. His term of office as President ended in 2016. Ladies and gentlemen, it gives me the greatest pleasure to invite one of our distinguished speaker, Advocate John Walters. You are welcome, sir.
Thank you so much, guys. Can you hear me now? Good mornings.
Good, we can hear you, Advocate Walters.
Thank you. And good morning to all the participants. And I notice they are from all over the world. Thank you for your interest in this very challenging topic. But thank you also for inviting me to share some of my experience as an ombudsman. My short presentation consists of 4 parts. That is one. The first is the introduction. The second topic will be the Ombudsman and Parliament. Then a third one will be enforcement through legal action. The fourth one will be enforcement through a special report, and then the conclusion. I start off with a quotation from a former colleague, Andre Marin, from the Ontario Ombudsman. And I quote, "Ombudsmen generally do not issue binding recommendations. This principle is well established in the tradition of the classical parliamentary ombudsman. We have achieved results we must achieve results without powers of compulsion, acting as the conscience of an institution by sharing our judgment about whether or not it is acting fairly and reasonably," unquote. The Ombudsman and Parliament. I believe that no ombudsman can function effectively without a healthy relationship and support from members of Parliament. Such support has to do with issues such as his or her credibility, his or her resources, implementation of his or her recommendations, and most importantly, his or her effectiveness. The Ombudsman is the investigative arm of Parliament. The Namibian Constitution and Ombudsman Act hold the Ombudsman accountable to the National Assembly by way of having to report to the National Assembly. The Act also empowers the Ombudsman to submit special reports to the National Assembly where institutions fail or are reluctant to implement the Ombudsman's recommendation. Unfortunately, the Act is silent on what the National Assembly should do with the reports. However, the standing rules of procedure and orders of the National Assembly provide that the National Assembly must refer the annual report of the Ombudsman to the relevant portfolio or select committee for evaluation and examination. As you can notice, it is mandatory from the word must. What evaluation and examination mean, is not spelled out in the standing rules. But it is my belief that the committee must use its powers to subpoena recalcitrant government officials to explain, among other things, why they have not complied with the Ombudsman's recommendations. This will ensure that the Ombudsman's recommendations are taken seriously and provide proof of Parliament's support for the Ombudsman. However, if there's no parliamentary select committee to support the Ombudsman, or the committee fails its duty and the Ombudsman's persuasive powers also fail, what else is left for the Ombudsman to do? I'll answer that question by the next topic, which is the enforcement through legal action. Experience has taught me to use the ultimate enforcement power when all others have failed, sometimes reluctantly, but it was necessary. I could find no Ombudsman legislation that provides expressly for enforcement through legal action. I interpreted the Ombudsman Act broadly and purposefully and used the complainant as co-litigant to establish locus standi for legal actions. An expensive route to follow, but one that yielded the expected results. The first case study. The Namibian cabinet passed a resolution which provided for the appointment of children of the liberation struggle, especially in entry-level positions in government offices, ministries, and agencies in reserve position without going through the formal recruitment process. As you all know, that cabinet resolutions are not law, and all appointments in government service must be done according or following the recruitment process. That did not happen, and on receipt of a complaint by an aggrieved citizen, the Ombudsman wrote and recommended to the Secretary of Cabinet to stop the practice because it is unlawful, irregular, and unfair. He ignored the recommendation, and I was forced to take the matter to the High Court. The court ruled in favor of the Ombudsman and set aside the decision of the Cabinet. Thereafter, the children of the liberation struggle approached the Ombudsman for assistance to hold the government accountable to its promise to provide them with employment. After consultations with them, the Ombudsman submitted a report to the Prime Minister in which he inter alia recommended that, and I quote, the government considers amending the Veterans Act number 2 of 2008 to include the children of the liberation struggle under a definition in the Act in order for them to benefit from projects which may be established under the Act and also benefit from the Veterans Fund also established under the Act, unquote. The National Assembly very recently requested the Ministry of Justice and the Ministry of Defense and Veterans Affairs to prepare amendments to the Veterans Act inter alia to include the children of the liberation struggle under a definition in order for them to receive the benefits provided for in the Act. The second case study is heading is enforcement through a special report. The inordinate delays in the preparation of appeal and review records of court proceedings and the reconstruction of lost and incomplete record of proceedings by clerks of court became a systemic issue which needed to be properly investigated and reported on with extensive recommendations for improvement. The Ombudsman carried out this investigation, and his special report entitled, "Is This Justice?" was tabled in the National Assembly. The report was referred to the Standing Committee on Constitutional and Legal Affairs. The committee's report was adopted by the National Assembly and recommended inter alia, and I quote, "Office of the Judiciary and Ministry of Justice should report progress to the Standing Committee on Constitutional and Legal Affairs and the Ombudsman on the findings, implementation, and enforcement of the recommendation contained in the special report," unquote. Unfortunately, I left office and never received such a progress report, but during the time in office, I witnessed improvement because fewer complaints about the above delays were received. Conclusion. In absence of a select committee of parliament in any country, or an ineffective committee is a serious impediment for genuine concerns of the Ombudsman's office and appropriate feedback for members of parliament. Not only is there no mechanism for scrutinizing Ombudsman's reports, but there is also no machinery for ensuring compliance with his or her recommendations. Such absence or ineffectiveness also causes absence of debates on the part of the National Assembly concerning the annual reports of the Ombudsman. In appropriate cases, guidance from a strong and competent parliamentary select committee must be more than welcome. I trust that we have erected a few signposts which the participants, which may provide a better insight to participants on how to address the thorny challenge of enforcement of Ombudsman's recommendation. I thank you, ladies and gentlemen, for listening to me, and I hope that we will have time to answer your questions. Hello? Hello?
Hello,
Are you
Advocate
getting
Walters.
me?
Oh,
Hello?
Can you hear me?
Yes, we can hear you.
Okay, okay.
Are you hearing me?
Yes,
Can you
I
hear
can
me?
you. Yes.
Okay. Thank you very much, Mr. Walters. Thank you for that brilliant and exceptional speaking note. Just a recap of what you have said. You said, amongst other things, the investigative arm of Parliament. This is particularly true with the Parliamentary Ombudsman institution, and which I believe Namibia is just an example. And one of the things you said in which Parliament can get access to the reports, the Ombudsman institution, is the annual report, which must be submitted to a select committee of Parliament for examination. Of course, in the annual report, you would have to state cases, how many are under investigation, how many were not implemented, and so on and so forth. And you also mentioned that the committee should call recalcitrant or institutions who have failed to implement the recommendations of the Ombudsman. I think that is very important to have and to ensure that the recommendations of the Ombudsman are implemented, because until and unless Parliament summons them, most of those recommendations will not be implemented, especially by recalcitrant respondents who are politically connected or who are major party stalwarts in the government. So I am very familiar with those hurdles. And you mentioned that the other thing which you advocated for is enforcement through legal action. And I think I am also one of the people who strongly support such a motion or such legislation to be for ombudsman institution, because in Africa you need stronger powers to ensure that recommendations, especially that of the ombudsman, are implemented. You said you mentioned the veteran case in Namibia, where you cited an example of where somebody complained about to stop the practice of employing children or relative of the liberation struggle or the liberation fighters from being employed without going through the proper procedure, due processes and procedure. And implicit in that, you can see a clear case or cases of injustices and maladministration, you know, where you may have people who are more competent than the children or relatives of the liberation struggle fighters, who may not be competent, but because there is a cabinet conclusion to that effect, they are employed whilst leaving those who are qualified unemployed. And you mentioned that a challenge was made, and you recommended, amongst other things, that policy or practice should be stopped. And also you said you spoke about enforcement to Parliament. I think even in our laws in SEL, you also have an issue of presenting special reports to Parliament where the need arises. And you said through that special report, you must table it in the National Assembly. And this is one of the ways in which you can get guidance from Parliament. And I thank you very much for such a presentation. You've been explicit, and we await questions that will be coming your way. Thank you very much.
Thank you.
Yes, Mr. Walters. Ladies and gentlemen, it's high time we listen to our next speaker. Our next speaker is from Punjab in India. Our next speaker is Honorable Dr. Mohammed Nasir Jamal Pasha. Mohammed Nasir Jamal Pasha. And he has a distinguished career spanning over 3 decades. Dr. Mohammed Nasir Jamal Pasha has steadily risen through the ranks of the Punjab Employees Social Security Institution, or PESI, serving with integrity and excellence. From his early days as a medical practitioner to his appointment as Director of Medical and Director Advisor, Dr. Pasha has demonstrated steadfast leadership in policy formulation, hospital operation, and public health administration. A result-oriented and self-motivated professional, Dr. Pasha has a strong foundation in medical data analysis, program development and design, and evaluation of health service delivery systems. His tenure included chairing key committees on cardiac care, medical procurement, disability boards, and COVID-19 management, showcasing his capacity for strategic and crisis-driven decision-making. Academically accomplished, Dr. Pasha holds a diploma in child health and an MBBS, I think that should be a medical degree, from the University of the Punjab. He has been recognized for outstanding civil service by the Chief Minister of Punjab. Throughout his career, he has combined scientific knowledge with strong communication, organizational and analytical skills, making impactful contributions to healthcare system and policies in Pakistan. I am therefore pleased to welcome Dr. Mohammed Nasir Jamal Pasha to give us his speaking note. Welcome, sir.
Thank you very much for your kind words, and good afternoon to all the honorable participants. It's a matter of privilege and honor to participate on this August forum for the presentation which I have prepared in connection with the topic which I have chosen, that is collaboration with external stakeholders to help exert pressure for implementation. And you are very seasoned people in this business. You must be knowing that issuing a recommendation or direction only is one part of the equation. The real challenge lies in ensuring those directions are meaningfully implemented. This is where power of the collaborative pressure from the external stakeholders becomes valuable. I'll give a short presentation in order to augment this role of stakeholders in achieving our implementation. Next. There are three cases which I'll be presenting in support of this topic. One is the medical professional negligence case against a doctor. Second is infant and child abduction in the hospitals. And third is the delayed payment of stipend to the girls going to the public sector schools in low literacy rate districts in Punjab. The very first case, which belongs to a medical professional negligence case against a doctor, the external stakeholders in this case were Pakistan Medical and Dental Council, which primarily is the legal body which regulates the professional conduct of a doctor. The second external stakeholder was Punjab Healthcare Commission, which ensures the service delivery and safety of the patients through minimum service delivery standards which are implemented in public and private hospitals across Punjab. Next. The case was that a newborn, almost 8 months old, was taken to a private hospital for circumcision, and due to the negligence of the doctor, the blood vessel was cut, and the sloughing of the male organ was occurred, and gangrene set in the male organs. The complaint, once we received it, we referred it to the Punjab Healthcare Commission, which ensures the service delivery in the public sector hospitals and the private hospitals. Next. They took action accordingly, and they sealed the operation theatre of the private hospital where the surgery was carried out. A fine of rupees 5 lakh was imposed, and the case of the professional medical negligence of the doctor was referred to the PMDC. The action which was taken by the Pakistan Medical and Dental Council against the doctor, according to the law, was that a disciplinary committee was constituted to inquire into the matter, where the complainant and the doctor, they were both heard. Expert opinion of the relevant specialist was taken, and ultimately the medical license of the doctor who carried out the procedure was cancelled, and He's not now allowed to practice medicine. The Office of the Ombudsman, however, is making arrangements for the affected child who is now about 2.5 years old for his reconstructive surgery because it has its anatomical and functional independence and alleviating his physical and psychological trauma. We thought it is our duty to ensure that to somehow we make his misery as less as possible. The second case which I wanted to present was that there were a few years ago there were many cases reported in the hospitals of regarding the abduction of the infants and the children from the hospitals, especially the newborn babies. The external stakeholders in this case were the Health Department, Government of the Punjab, Police Department, Safe Cities Authorities, which monitors the city through CCTV cameras, medical superintendents of the public sector hospitals, and the Vice Chancellor of the medical universities. We developed SOPs and guidelines in collaboration with all these stakeholders. These guidelines were prepared ensuring the safety of a child infant from the time he's born, he or she is born, until his or her discharge from the hospital. These guidelines were displayed in all the nurseries and gynaes of the public sector hospitals. Deployment of the security guards were ensured at strategic places. The CCTV cameras, which cover the whole city, was integrated with the hospitals to ensure the movement in case, God forbid, of abduction of the infant or child occurs. And the process of the handing over the newborn baby to the mother or the guardian was made through a pictorial evidence. Next. These guidelines were then the Office of the Ombudsman ensured that these guidelines are prepared and implemented. We sought a implementation report from all the stakeholders and all the hospitals where these incidents occurred. And I'm proud to say that now for the last 3 years, no such incident has occurred, and we are lucky enough that these systems, the guidelines and the SOPs that we prepared are still in place. And time to time, we randomly check their sustainability as well. The third case which I wanted to place before the August forum was that there was multiple complaints regarding the payment of stipend to the girls who go to the public sector schools in low literacy rate districts. From one district, we received almost 110 complaints over a period of 6 months. In this case, the stakeholders were the schools where the student was registered, the district monitoring officer, Punjab Social Protection Authority, School Education Department, and Project Management Information Unit, and bank. We identified, we convened a meeting of all these stakeholders here in the Office of the Ombudsman Punjab, and we identified the reason for delay in the payment of this scholarship, which is being given to these girls as an incentive for enhancing the literacy rate amongst the girls from grade 4 to grade 10. There were multiple reasons. For instance, incorrect data at the time of the enrollment of the student, data entry validation issues, inadequate communication channels, monitoring mechanisms. There was no targeted outreach campaigns, lack of the capacity building and collaborative approach was not there, linkage with the school information system, database was not available, lack of the guidance at the school was lacking, and no effective role of the district monitoring officer was seen. Then we prepared a checklist with the responsibility metrics defining the role of each stakeholder. The awareness campaign flexes were prepared and displayed in all the schools. The schools were made to nominate dedicated focal persons, ensuring guidance, correct data entry, and submission of the required documents before initiating the process. The instructions for the parents of the girls were displayed in all the schools. Social protection helpline has been established now. Grievance redressal access has been made available at each step of the process. The implementation through this process, which he worked out in collaboration with the stakeholders, we have achieved that now the training and the guidance is a continuous process for those who are involved in this process. There has been a standardized reporting format has been established. Data verification and validation is being carried out. Clear communication channels have been established. Monitoring and feedback mechanism is there. There is a collaborative approach which has been ensured through the IT-based interventions. Regular capacity building is done, and centralized dashboard for stakeholders has been in place after this intervention by the Office of the Ombudsman. So these are a few examples where you can see that with the help of the stakeholders, we were able to implement the directions or the recommendations of the Honorable Ombudsman. And if you can see, these implementations were made in such a way that its sustainability was also ensured. And it is, in my opinion, this collaboration with an external stakeholder is necessary to close the gap between the recommendation and the reality. So a little bit effort on part of the Office of the Ombudsman and exertion of the pressure on the stakeholders gave us the desired results. In the end, I would like to comment on this August forum, which is, I think, is a learning platform for everybody, and I'm happy to hear the two presentations which were made earlier, and it was a great learning for me. And before closing my session, I would say we are allies in a shared mission, and we must share our experiences with each other for achieving our target, which is the identification of the maladministration and protection of the right of citizens, ensuring that public bodies are held to the highest of the standards. Thank you.
Thank you very much, Dr. Pasha. That was an excellent presentation. You getting me?
Yeah, I'm hearing you.
Okay. All right. Thank you very, very much for that excellent presentation. Just a synopsis or a recap of your presentation for the benefit of our listenership. You spoke on, first of all, what is medical negligence and where into which institution medical negligence can be reported. You spoke on the fact that medical negligence can be reported to or be made to the Pakistan Medical and Dental Council. And you also mentioned that for the case of the 8-month-old babies whose male genitalia was damaged because of the medical negligence of a certain doctor, so such report was also sent to the Punjab Healthcare Commission. And of course, this is very frequent, I would say, in Africa, where we have doctors perform surgeries that go bad. Doctors sometimes do things that you cannot explain. You would expect better from medical practitioners of their standard or caliber. You also mentioned the case of where the case was referred to the Punjab Health Commission, who also referred the matter to the Medical and Dental Council of Pakistan, where they had punitive measures against the doctor, including not only the commission fining him, but his license was cancelled by council. That's very important. You spoke about the infant child abduction, which is also very common in Africa, and particularly also in my country. Well, particularly we've had, on the issue of medical negligence, we have had complaints from citizens, especially mothers whose children may have died due to the negligence of doctors, whose children or other relatives may have suffered some botch surgery and the likes. You know, they have brought those complaints to us. And well, not in my tenure, but from the records, my predecessor did recommend for compensation to be paid to those people. And then, like you said, they would also recommend for reconstructive surgeries to take place. You mentioned the issue of delay payment of stipend to girls going to public schools, you know, in low literacy rates district. You know, in my country, we have this free quality education. So I also received similar complaint of subventions not coming on time, teaching and learning material not coming on time. So we usually forward such complaints to the Ministry of Basic and Senior Education so that they would ensure that these schools, particularly in the hard-to-reach areas, have the necessary materials that are needed. So I'm sure this is similar to your explanation in the delay of payment of stipend to girls. So we are grateful for such presentation, which was excellent, and I believe that our listeners have heard you and may take your suggestion into good practice. Thank you very much for that excellent presentation. Now, ladies and gentlemen, we are now coming to our Q&A session, where before now some people have sent in their questions, which will be, those questions will be sent to the various speakers who would have to address them. They have 2 minutes each to address this question. So whilst I give you the questions, please may I have your attention on those questions. So the first question is this: what are the most effective levers to ensure, hello?
Yes, we can hear you, Honorable.
Oh, okay, I see everybody is offline, so I'm wondering.
No, we can hear you.
Okay, so the first question is, what are the most effective levers to ensure the implementation of the Ombudsman recommendation in resistant administrative systems? So I think the question should go to, first of all, Honorable Sokoni, and then to Mr. Walters. You have 2 minutes each to answer.
You kindly repeat the question?
Okay, the question is, what are the most effective levers, as in L-E-V-E-R-S, levers to ensure the implementation of the Ombudsman recommendations in resistant administrative systems, in systems or in countries where people are resisting administrative changes?
Okay, thank you so much for that question. In the first place, the Ombudsman is normally appointed by way of a constitutional provision. And those constitutional provisions are actually supposed to protect the Ombudsman in when he issues a report and tries to get compliance from the from the state institutions. First of all, if I take the example from Zambia, the report is actually issued to the state institutions, and they are given 90 days within which to respond to the report of the Ombudsman. I think that is a very effective tool, because it gives the respondent institutions time to converse with the Ombudsman institution to understand why it is that a recommendation has been written in that particular way. And the complainant is given the same 90 days. And it is only after those 90 days that actually the report of the Ombudsman becomes binding. And then secondly, the issue of naming and shaming. The Ombudsman is allowed to publish the reports, and at the same time, the Ombudsman submits those reports as well to Parliament. And Parliament can actually call upon that institution to answer before Parliament as to why they are not implementing the recommendations of the Ombudsman. In an executive system, because I've also worked in an executive system, I don't know why I actually got better compliance under the executive system. I suppose because the president, as head of the executive, was monitoring what was going on within the executive because of the reports of the Ombudsman, and there was no report of the Ombudsman that was ever rejected. So I would say that the fact that the Ombudsman has got that leeway to publish the reports is a very effective monitoring tool to ensure that we get compliance. And when I actually said that we have only 30% compliance from the respondent institutions, this is mostly in those cases where I would call them systemic issues, where, for example, they are not paying the allowances to civil servants, which are the majority of the cases which come from the civil service. But otherwise, if the system is monitored very, very strictly, I don't see the reason why we should not get a higher compliance level. Thank you.
All right, thank you very much. Thank you very much, Honorable Sokoni. Mr. Walters? Mr. Walters with us?
Yes, can you hear me? In my career, I
Yes.
did not like to be ignored. When I made a recommendation, and that was from, I believe, from a body created by constitution and law. And any person, be it a minister or who else, ignore my recommendation, I will do the necessary and follow-up letters, but thereafter I approach the court. As you said, that is the most effective way. When persons will listen to you, ministries will listen to you, and I proved on many occasions that that was the only way my recommendations were implemented. It went so far that I had to file another court application where a minister did not comply with the order of court, and I filed a court proceedings for contempt of court. Luckily for her, and unfortunately for me,
Oh, all right. Thank you.
Did not agree with me. So that is my
all right.
ultimate weapon for ensuring the implementation of your recommendation. But I don't know whether all ombudsmen have this kind of leverage in their laws or other means to force enforcement. Thank you.
All right. Okay. Thank you very much, Mr. Walters. Because of time, I would suggest that the speakers just record these questions and then you answer. I'll give you 2 minutes each to answer them. So because of time, just write these questions down. I have about 5 more questions so that we share them evenly, so that I have 2 minutes each to answer them, so that we beat time. Okay. So the second question, this goes back to you, Honorable Sokoni, Mr. Walters, and of course, Dr. Pasha. How can cooperation between mediation institutions and parliament be strengthened to ensure institutional follow-up of recommendations? How can cooperation between mediation institutions or ombudsman institutions and parliament be strengthened to ensure institutional follow-up of recommendation or institutional implementation of recommendations? Number 3, can the role of civil society be institutionalized in the implementation process? Can the role of civil society be institutionalized in the implementation process? You know, I remember Madam Sokoni did mention something about civil society. And also the other question is, are there any concrete examples of sanctions or incentives put in place to compel administrations to comply with recommendations of the Ombudsman? Are there any concrete examples or case studies of sanctions or incentives put in place to compel administrations to comply with recommendations? And lastly, what role do non-binding recommendations play in a rapidly changing political environment? This is very interesting. What role do non-binding recommendations play in a rapidly changing political environment? So we start with you, our dear Madam Sokoni.
Thank
Hello,
you
Madam,
very much.
are you getting us?
Yes, yes. Would you like me to run through all the questions, to answer all the questions?
Yes, yes. Or those you can answer.
Okay, well, those I can answer. So what are the most effective levers for the implementation to ensure the implementation of recommendations of ombudsmen? I think that's as much as I got.
Yes.
This wasn't the first one. Okay. So I think I'll answer the second one. How can cooperation between mediation institutions and parliaments be strengthened to ensure institutional compliance? So I think the first thing that I can talk about is to ensure the excellence of the reports that you submit to parliaments. The quality of the reporting should be very, very high. And also the integrity of the reports to ensure that you are presenting both sides of the story before Parliament and applying the law. And then we have also established that when you give the Parliament very, very long reports which are not readable, you don't get the required result from Parliament. So whenever we prepare a report, we also prepare an executive summary. And then also talking to parliamentarians, having workshops with parliamentarians, because Parliament changes almost every five years. You have different MPs coming into office. So also talking to Parliament is also very, very important. The last issue that I would state is that regularly ensuring that the state institutions also are given orientation as to what the powers of the public protector are, what is the relationship between Parliament, so that they understand the mandate of the institution. I mean, it's a three-way, four-way square. The other question, can the role of civil society be institutionalized in the implementation process? we sign memorandums of understanding with civil society organizations. And for example, with the Disabilities Rights Watch, if we are investigating a matter to do with a person who is disabled, we actually involve them to ensure we understand what it is that we are investigating. And a lot of these disabled people also are not able to read and write. They actually help us in having these complaints reduced to writing. And when the report comes out, it's possible to actually share it with them as well, so that if there are any policy issues which they want to input, it can be done. So we use the memorandum of understanding, which we sign with these civil society organizations. And our act also enables us to
Okay, madam, sorry, madam.
Yes.
Sorry, ma'am, can I hold you there so that we give opportunity to others, because we barely have 10 minutes or less than 10 minutes. Thank you very much for this intelligent.
Thank you so much. Thank you.
No, yeah, that's why I said you can run through, but because of time, let's just give one more question to the same question for Mr. Walters to answer and Dr. Pasha.
Okay.
Okay.
All right, thank you, ma'am. Because of time. Yes,
yes.
Dr. Walters, 1 minute.
Very briefly, depending on your legislation, the Ombudsman, Namibian Ombudsman's Act, dated from June 1990. Now you all can realize that act is not it does not fit into the development of Ombudsman all over the world. It is outdated. So we since 2015, when I was still in office, I tried to have a new act for the Ombudsman. We drafted it, sent it to the Ministry of Justice to put it Parliament. Eventually, a year or two ago, but it was not. It was withdrawn by the then Minister of Justice. But what I'm trying to say, ombudsmen would look at that and at the legislation and continuously look at gaps and try to see how they can fill in so that the legislation give them the necessary powers. For example, nowhere in the Ombudsman Act saying the Ombudsman may go to court and enforce his recommendation, enforcement of your recommendation. But as I said, I interpret the law, use a complainant in order to take that route. But it is an expensive route, and not all ombudsmen can do that. But I agree, and as I said, that no ombudsman can have a healthy and relationship, effective and healthy relationship with Parliament. And that is it. You must establish that and maintain that healthy relationship to Parliament. But you must also ensure that Parliament listen to you. The annual report, I've learned through experience that in my annual report, I usually already have done all the necessary. I just report that I have taken this matter to court, and in fact, I don't need your assistance to enforce my recommendations. So that is what I said. Your weapon is your legislation.
Yeah, thank you very much, Mr. Walters. Can I also hear from Dr. Pasha? Dr. Pasha, you have 30 seconds or 1 minute. Can we say that? Dr. Pasha, are you with us?
Yeah, I am with you, very much with you.
Any of the questions, you can answer any of those questions.
Come again?
Hello?
Yeah.
I have given 5 questions. You can choose any one of them if you so wish to answer them, because time is catching up with us.
Probably I'll comment on the legal sanctity of the recommendations by the Ombudsman, which I have gathered from the Honorable John Walters that you need to change the act and the ordinance in order to get your implementation as is required by the Office of the Ombudsman. We have certain steps in order to ensure our implementation, because once we have prepared our case, which fits in all the legal parameters of the complaint, then it's very easy to get it implemented through a forum which has the implementing powers. So we usually don't see any compelling forces which may hinder in implementation of our recommendations or the directions, whatever the case may be.
Okay. Thank you very much, Dr. Pasha. We are grateful for that. However, we want to apologize to other pre-submitted questions which the speakers were unable to answer due to time constraints, but those questions will be sent to each and every one of them. And please, Honorable Sokoni, Madam Sokoni, Honorable Walters, Dr. Pasha, will send the questions privately to your email. Please take your time to answer them so that we provide the answers to our listeners and those who have submitted those questions, you know, so that we could help them understand what the whole topic was about, how they can get effective implementation of the Ombudsman recommendation, and how to make their institutions very serviceable or deliver on their mandates to the people which they are set up to serve. Okay, so thank you very much. But before we go, can you have just 1 second of your last statement? Dr. Pasha, just 1 second. Do you have anything to say as your last statement before we leave the forum?
I just wanted to thank you for this webinar which you arranged. It was very learning, and I wish that it should be continued and made a regular practice, because sharing our experiences will help us a lot. Will help us resolve our certain queries which we face in our daily complaint resolving mechanism. Thank you very much.
Thank you very much, Dr. Pasha. Honorable Walters, last statement, please. Last comment.
Just to remind you that I'm in no position to be called the honorable. I am an ordinary citizen, but thank you so much for having the opportunity to share some of the insights I still have. And greetings to everybody, and my best wishes to all ombudsmen all over the world.
Thank you very much, Mr. Walters. But you are still honorable. Once an honorable, always an honorable. No. And now we go to Honorable Madam Sokoni, the Iron Lady.
Thank you very much. Thank you to everybody who took time to listen. All I can say, what we are basically talking about is communication. How do we communicate our message to the respondents? How do we communicate our message to complainants? How do we communicate our message to Parliament? So this is what we've been talking about, and this is what we should improve on, our communication skills. Thank you.
Yeah, thank you very much. And please, once more, the questions will be sent to you so that you answer them and that we give them back to the people who send the questions to us. Thank you very much. You have been exceptionally brilliant in your presentation to this body, and we are so grateful. We also want to extend our immense thanks and appreciation to the AORC. And with as Dr. Pasha said, we should be having this this webinar very frequently, so that in as much as we cannot gather in one place because of time and resources, but this monthly or weekly webinars will help improve on our service delivery to our people, and then help us to cultivate best practices that will ensure that the Ombudsman's offices or institutions in our respective countries deliver on their mandate to the people. Thank you very much. It has been a pleasure serving as your facilitator. Thank you very much. So could we call on Marion Adonis to give us the vote of thanks? Marion?
Thank you, Honorable Facilitator. Good day, everyone. I would like to extend a heartfelt thank you to all who made this session possible. To our speakers, Honorable Caroline Sokoni, Advocate John Walters, and Dr. Nasir, Jamal Pasha. Thank you for so generously sharing your expertise and experiences. You've reminded us that meaningful implementation requires strong internal systems, strategic external partnerships, and at times courageous action to overcome resistance. Your insights have equipped us with practical tools and offered fresh perspectives, especially for those who may be struggling to get their recommendations implemented. To our facilitator, Honorable Tejan Ahmed Israel Jar, thank you for steering the session with such professionalism and ease. Your thoughtful engagement helped keep the discussions both focused and inclusive. To our board chairperson, Advocate Koleka Galeka, thank you for your continued leadership and unwavering support of AORC's mission to strengthen ombudsman institutions across the continent. A special word of appreciation to Hazel Langer from UKZN Corporate Relations, the quiet force behind the scenes who ensures that our webinars run smoothly. Hazel, your attention to detail, calm presence, and consistent professionalism are deeply valued. We thank you sincerely. Thank you to all our partners, especially the IOI, for your support. These events would not be possible without your commitment and teamwork as well. And most importantly, to our participants, thank you for showing up in such impressive numbers. Over 311 people registered, representing 63 countries across 6 continents: Africa, Asia, Europe, North America, Oceania, and the Caribbean. 226 attendees joined us live today. This remarkable global reach speaks volumes about the growing interest in ombudsman work and the relevance of today's discussions. It also reflects the widening footprint of AORC as a trusted platform for learning, collaboration, and dialogue. We hope you leave today not only informed, but inspired to follow through, to engage more deeply, and to help ensure that ombudsman recommendations are not only heard, but implemented and lived. Thank you once again. Until we meet again, stay well, stay engaged, and stay committed to justice. Bye-bye. Thank you.
Bye-bye.
Thank you.
Bye.
Thank you.
Thank you very
Bye.
much.
Pleasure.
Bye.
Greetings, Caroline.
Bye. Thank you very much.
Thank you so much, John.
Okay.
Goodbye.